I knew something was wrong the moment I saw the envelope from the Meadowbrook Estates, HOA, wedged into my mailbox on that sweltering Tuesday afternoon in August. My name, Xavier Brooks, was printed in that generic computer font across the front, and the return address bore the familiar emblem I had come to associate with petty bureaucracy and neighborhood power trips. I pulled into my driveway in Gilbert, Arizona, where I had lived for the past 3 years in relative peace. The house was a modest single-story ranch with a decent yard, and I had been fortunate enough to avoid most of the HOA drama that seemed to plague my neighbors. Until now, apparently. Inside, I tossed my keys onto the kitchen counter and tore open the envelope. What I read made my blood pressure spike immediately. It was an invoice for $7,300 for sidewalk repair and replacement. The letter stated that during a recent inspection, the HOA board had determined that the walkway leading from the street to my front door was cracked, uneven, and posed a safety hazard to the community. They were billing me for the complete removal and replacement of the entire walkway, and the work was scheduled to begin in 2 weeks. I read it again, certain I was missing something. The walkway they were referring to was the stone path that ran from the public sidewalk, across my front lawn, straight to my porch. I had installed it myself 2 years ago after the builder's original concrete path had deteriorated. I had spent weeks choosing the right pavers, laying them carefully, ensuring proper drainage. That walkway was entirely on my property, not on HOA common ground, not on a shared space. My property. I immediately called the number listed on the invoice. A woman answered on the 3rd ring. Meadowbrook Estates HOA, this is Linda speaking. Hi Linda, this is Xavier Brooks from 2847 Desert Willow Drive. I just received an invoice for sidewalk repairs and I think there has been a mistake. Let me pull up your file. One moment. I heard keyboard clicking. Yes, Mr. Brooks. The board conducted an inspection last week and noted significant deterioration of your front walkway. The repair has been approved and scheduled. Linda, that walkway is on my private property. The HOA has no authority over it. There was a pause. The board determined it falls under community standards. All exterior improvements require HOA approval, and maintenance of walkways is the responsibility of the homeowner. However, when repairs exceed a certain threshold, the HOA contracts the work to ensure uniformity. That makes no sense. I installed that walkway myself. It is entirely within my property lines. I am just relaying what the board has decided, Mr. Brooks. If you have concerns, you will need to bring them to the monthly meeting next Thursday at 7 p.m. I hung up, frustrated but knowing that arguing with the administrative assistant would get me nowhere. I needed documentation, proof, and a plan. That evening, I dug through my filing cabinet until I found my property survey from when I purchased the house. The document clearly showed my property boundaries, and I traced the line with my finger. The walkway was well within my lot, at least 15 feet from the property line at its closest point. There was no easement, no shared access notation, nothing that would give the HOA any claim to it. I took photos of the walkway from every angle. Honestly, it looked fine. There were no cracks, no uneven pavers, no safety hazards whatsoever. I had used high-quality materials and proper base preparation. This was either a case of mistaken identity or something more deliberate. The next morning, I called a lawyer I knew from my gym, Marcus Chen, who specialized in real estate and property disputes. I explained the situation over coffee at a local shop. You have your CC and Articus? He asked, referring to the covenants, conditions, and restrictions that govern HOA communities. I have them somewhere. I have not looked at them in years. You need to read through them carefully. HOAs have broad authority, but it is not unlimited. If your walkway is genuinely on your private property and does not impact common areas, they typically cannot force you to replace it, let alone bill you for contractor work you did not authorize. That is what I thought. But, Marcus continued, some HOAs have provisions about aesthetic standards and uniformity. They might argue that your stone pavers do not match the community standard of concrete walkways. I installed them 2 years ago. No one said anything then. Did you submit an architectural review request before installing them? I felt my stomach sink. No, it was just a walkway. I did not think I needed permission to improve my own property. Marcus gave me a sympathetic look. That might be your problem. Most HOAs require approval for any exterior modifications. If you did not get approval, they could claim the installation was unauthorized. So they can force me to rip out a perfectly good walkway because I did not file paperwork. They can try. Whether they will succeed is another matter. But the fact that they are billing you for work you did not authorize is concerning. You need to attend that meeting and fight this. I spent the next week preparing. I printed out copies of my property survey, photos of the walkway, documentation of the materials I used and their cost, and I researched Arizona HOA law extensively. I learned that while HOAs have significant power, they cannot simply charge homeowners for unsolicited work without proper notice and due process. Thursday evening arrived, and I walked into the community center, where the HOA meetings were held. The room was set up with rows of chairs facing a long table where the board members sat. I recognized a few of my neighbors, but most of the attendees were unfamiliar faces. At the center of the table sat Sharon Patterson, the HOA president. She was in her mid-50s with short blonde hair that looked like it had been styled specifically to complement her permanent expression of disapproval. To her right was the vice president, a thin man named Gary who always wore polo shirts tucked into khaki pants. To her left was the treasurer, a woman named Diane who I had never actually heard speak. Sharon called the meeting to order with a sharp rap of her gavel. They went through the usual business: approval of minutes, financial reports, discussion of the upcoming community garage sale. I sat there, my folder of documents on my lap, waiting for the opportunity to speak. Finally, Sharon said, "We will now open the floor for homeowner comments. Please state your name and address for the record." I stood up. Xavier Brooks, 2847 Desert Willow Drive. I am here about the invoice I received for sidewalk repairs. Sharon's expression tightened. Yes, Mr. Brooks, your property was flagged during our quarterly inspection. The walkway is in violation of community standards. Can you explain what violation? I have photos here showing the walkway is in excellent condition. The violation is that you installed non-standard pavers without architectural approval. All front walkways in Meadowbrook Estates must be concrete to maintain community uniformity. I was not aware of that requirement. I have lived here 3 years and have never seen that documented anywhere. Sharon pulled out a binder. It is in Section 12, Paragraph 4 of the CC and Articles. All exterior modifications require written approval from the Architectural Review Committee. Okay, but that does not explain why you are billing me $7,000 for work I did not request or approve. The board determined that the violation must be corrected. Rather than placing the burden of finding contractors and managing the project on you, we have arranged for the work to be completed by a qualified contractor. You are being billed for the service. That is not how this works, I said, feeling my frustration rising. You cannot force me to hire a contractor I did not choose and then bill me for it. And more importantly, this walkway is entirely on my private property. The HOA has no jurisdiction over it. All property within Meadowbrook Estates falls under HOA authority, Sharon said firmly. That is not accurate. I have my property survey here. I walked forward and handed copies to each board member. As you can see, the walkway is well within my property boundaries. There is no easement, no common area designation. It is my property and I can maintain it as I see fit. Sharon barely glanced at the survey. The architectural standards apply regardless of property lines. When you purchased your home, you agreed to abide by all HOA rules. I agreed to reasonable restrictions. I did not agree to let you bulldoze my property and send me a bill. Mr. Brooks, the decision has been made. The work is scheduled for next Monday. If you refuse to allow access, we will place a lien on your property. The room fell silent. A few neighbors shifted uncomfortably in their seats. You are going to place a lien on my house because I will not let you destroy a walkway that is on my property and in perfect condition. We are enforcing community standards. This meeting is not a debate. You had the opportunity to voice your concerns, and they have been noted. Next item on the agenda. I stood there for a moment, stunned by the dismissal. Then I gathered my documents and walked out. As I left, I heard someone behind me whisper, "That is not right." I called Marcus Chen the next morning and explained what happened. They threatened a lien. He asked, his tone sharp. Yes, Sharon said if I do not allow them access to remove my walkway, they will lien the property. That is aggressive and likely improper. Xavier, I think you need to send them a formal cease and desist letter. Make it clear that you are not authorizing any work, that the property is private, and that any attempt to perform work without your consent will be considered trespassing and property destruction. Can you draft that? Absolutely. I will have it ready by this afternoon. We will send it certified mail, so there is no question they received it. The letter went out Friday afternoon. In it, Marcus clearly outlined my position. The walkway was on my private property. I had not authorized any repairs. The HOA had no legal authority to perform work without my consent, and any attempt to do so would result in immediate legal action. He cited specific Arizona statutes regarding HOA authority and property rights. Saturday morning, I was in my garage organizing tools when I heard a vehicle pull up. I walked around to the front and saw Sharon Patterson getting out of a white Lexus SUV. She was wearing sunglasses despite the cloudy weather and carried a clipboard. "Mr. Brooks," she said, her tone clipped. "I received your lawyer's letter. Good. Then you understand my position. I understand that you are being difficult. The board is trying to maintain property values for everyone in this community. Your non-compliant walkway is an eyesore." I looked at the walkway. It was beautiful natural stone, professionally laid with clean lines and proper edging. An eyesore. Sharon, it looks better than half the concrete walkways in this neighborhood. That is not the point. The point is uniformity. The point is following the rules. The rule is that I need approval for modifications. Fine, I did not get approval. But the consequence for that is not you coming onto my property and destroying what I built. At most, you could fine me, but you cannot force me to remove it. The CC and Articus give the board authority to correct violations at the homeowner's expense, not on private property without consent. That is what my lawyer's letter explains. Sharon stepped closer, her voice lowering. "Xavier, I am trying to help you here. If you do not cooperate, this is going to get very expensive for you. Legal fees, fines, liens. Is that really what you want? What I want is for you to respect my property rights. The walkway stays. If you have a problem with that, you can take it up with a judge." Her jaw tightened. "You are making a mistake." "No, Sharon, you are the one making a mistake. And if any contractors show up on my property Monday morning, I will call the police." She turned and walked back to her SUV without another word. As she drove away, I noticed my neighbor across the street, an older man named Robert, watching from his porch. He gave me a slight nod. Monday morning, I worked from home, keeping an eye on the front yard. At 8:30, a white pickup truck with desert stone and concrete printed on the side pulled up to my curb. Two men got out, both wearing work boots and high-visibility vests. I stepped outside before they could even approach the walkway. "Can I help you?" I asked. The older of the two men, who had a thick mustache and a clipboard, said, "We are here to remove and replace the front walkway. Are you the homeowner?" "I am, and I did not hire you." He looked confused. "The HOA contracted us. We have a work order." I sent the HOA a cease and desist letter. "I am not authorizing any work on my property. If you touch anything, I will consider it trespassing and property destruction." The two men exchanged glances. The older one pulled out his phone and made a call. I heard him say, "Yeah, the homeowner is here. He says he did not authorize the work. What do you want us to do?" There was a pause, then he hung up. "Our contact at the HOA says the work was approved by the board and we should proceed." "Who is your contact?" "Sharon Patterson." "Okay, here is what is going to happen. I am going to call the Gilbert Police Department. When they arrive, I am going to show them my property survey, my cease and desist letter, and explain that you are attempting to destroy my property without permission. You will likely be asked to leave. Your company might face charges, or you can leave now and take it up with Sharon." The contractor looked frustrated but not hostile. "Look, man, we are just trying to do our job. We got paid to do the work. I understand that, and I am sorry you are caught in the middle. But this is a dispute between me and the HOA. You should not be here." He sighed heavily, then motioned to his partner. "Come on, let us call the office." They got back in their truck and drove away. I immediately called Marcus Chen and left a voicemail explaining what happened. Within an hour, I received an email from the HOA's management company. It stated that I was in violation of the cease work order, that my refusal to allow contracted repairs constituted obstruction, and that I was being fined $500. Additionally, the email said that the board was scheduling a hearing to discuss further action, including the possibility of foreclosure proceedings. Foreclosure over a walkway. I forwarded the email to Marcus, who called me back within minutes. "They are bluffing," he said. "They cannot foreclose on your home because you would not let them destroy your property. But they can make your life difficult. I think it is time to go on the offensive." "What do you mean?" "File a lawsuit. Sue the HOA for harassment, for attempting to unlawfully damage your property, and for abuse of authority. We will also seek an injunction preventing them from taking any further action regarding the walkway." "That sounds expensive." "It will be. But if we win, you can recover your legal fees. And honestly, Xavier, I do not think you have much choice. Sharon Patterson is not going to back down unless a judge makes her." I agreed, and Marcus filed the lawsuit the next day in Maricopa County Superior Court. We sued the Meadowbrook Estates, HOA, Sharon Patterson individually, and the management company for good measure. The complaint outlined the timeline of events, cited the relevant property laws, and requested both compensatory and punitive damages. The lawsuit hit the local news within a week. A reporter from the Arizona Republic called me, and I agreed to an interview. The story ran with the headline, "Gilbert Homeowner Sues HOA Over Walkway Dispute." It detailed the facts and included a statement from Sharon Patterson, who said, The board is committed to maintaining property values and enforcing community standards. We stand by our actions. The article generated significant attention. I received emails and messages from other homeowners in Meadowbrook Estates, sharing their own stories of HOA overreach. One woman, Helen Tanner, reached out to say that Sharon had tried to fine her for painting her front door a shade of red that was supposedly not approved, even though it matched the approved color palette exactly. Another homeowner said he had been cited for parking his work truck in his own driveway overnight. Marcus suggested we organize a meeting with these homeowners. If there is a pattern of abuse, it strengthens your case. It shows this is not just about you. We met at a coffee shop the following Saturday. 8 homeowners showed up, each with their own story of harassment, improper fines, and arbitrary enforcement. Helen Tanner became the most vocal, expressing frustration that had clearly been building for years. Sharon runs this HOA like her personal fiefdom, Helen said, her voice trembling with anger. She has fined people for things that are not even in the CC and Articus. She plays favorites. If she likes you, you can get away with anything. If she does not, she will find a reason to make your life miserable. Has anyone tried to challenge her before? I asked. A few people tried, Helen said, but she intimidates them, threatens liens, foreclosure, legal action. Most people just pay the fines and move on because fighting is too expensive. That is exactly what she is counting on, Marcus said. But if we can show a pattern of abuse, we might be able to force the entire board to resign and get the management company replaced. Over the next few weeks, Marcus gathered affidavits from multiple homeowners detailing Sharon's actions. He also subpoenaed HOA financial records, which revealed some interesting discrepancies. The budget showed significant expenditures for legal and administrative costs, but the invoices were vague and lacked detail. There were also payments to a landscaping company owned by Sharon's husband. This is a problem, Marcus said when he showed me the records. If Sharon is funneling HOA money to her husband's business without proper disclosure, that is self-dealing. It might even be embezzlement. Are you serious? Look at this. The HOA paid $60,000 last year to Patterson Landscaping. But the services rendered are not clearly documented. Routine maintenance, major projects, it is unclear, and there is no evidence that the board solicited competitive bids, which is usually required for contracts of this size. So Sharon has been using the HOA as a personal piggy bank. Potentially. We need to dig deeper, but this could be much bigger than a walkway dispute. As the court date approached, Sharon's behavior became increasingly erratic. She started sending emails to all residents, calling me a troublemaker and claiming I was jeopardizing the community's financial stability by forcing the HOA to spend money on legal defense. She organized a recall petition to remove me from the community, which made no sense because HOA membership was not voluntary. Then, in early October, something unexpected happened. I received a call from a woman named Patricia who said she was on the board of directors for the management company that oversaw Meadowbrook Estates. "Mr. Brooks, I wanted to reach out personally to discuss the situation," she said, her tone professional but cautious. "Okay. We have been reviewing the matter internally, and we believe there may have been some miscommunications and procedural errors. We would like to resolve this without further litigation. What kind of resolution are you proposing?" "We are prepared to withdraw all fines and the invoice for the walkway repairs. We will also issue a formal apology and agree that the walkway is your private property and not subject to HOA oversight." That is a start. What about the financial irregularities? There was a long pause. What financial irregularities? The payments to Sharon Patterson's husband's landscaping company, the lack of proper documentation for expenditures, the self-dealing. I was not aware of those issues. Then you should be. My lawyer has the records. If the management company was complicit in allowing Sharon to embezzle HOA funds, you have a serious problem. Mr. Brooks, I assure you that if there are financial improprieties, we will investigate them thoroughly. But that is separate from the Walkway issue. Can we at least resolve that dispute? I will discuss it with my attorney. I hung up and called Marcus immediately. He was skeptical of the offer. They are trying to limit their liability, he said. If they settle the Walkway issue quietly, they hope you will drop the rest of it. But I think we have them on the ropes. The financial stuff is serious. If Sharon has been embezzling, that is criminal. Should we go to the police? Not yet. Let us see what the management company's investigation turns up. If they try to cover it up, then we go to the authorities. 2 weeks later, I received another call from Patricia. Her tone was markedly different. Mr. Brooks, I want to inform you that Sharon Patterson has been removed from the board of directors, effective immediately. We have also terminated our management contract with Meadowbrook Estates, pending a full audit of the HOA's finances. What did you find? I cannot discuss specifics, but there are significant concerns about financial mismanagement. We are cooperating with an independent auditor, and if criminal activity is suspected, we will refer the matter to law enforcement. Good. What about my lawsuit? We are prepared to settle on the terms I outlined before, with the addition of covering your legal fees up to a reasonable amount. Marcus and I discussed the offer. The financial discrepancies were being investigated, Sharon was gone, and I would be made whole financially. It seemed like a reasonable resolution. But, Marcus said, I think we should still push for the criminal investigation. If Sharon embezzled money, she should face consequences. I agree. Let us settle the lawsuit but make it clear that we are not dropping the financial investigation. We accepted the settlement. The HOA issued a formal letter acknowledging that my walkway was private property, withdrawing all fines and apologizing for the overreach. They also paid Marcus's legal fees, which totaled nearly $12,000. The independent audit took another 2 months, but the findings were damning. Sharon Patterson and her husband had siphoned over $150,000 from the HOA over a 4-year period through fraudulent invoices, inflated service charges, and outright embezzlement. The report was referred to the Maricopa County Attorney's Office. In December, Sharon Patterson was arrested and charged with theft, fraud, and misuse of HOA funds. Her husband was also charged as a co-conspirator. The case made local news again, and I was contacted by several reporters for comment. I just wanted to keep my walkway, I told one reporter. But when you stand up to bullies, sometimes you uncover much bigger problems. Sharon's arrest had a ripple effect in Meadowbrook Estates. The remaining board members resigned, and a special election was held to select new leadership. Helen Tanner ran for president and won overwhelmingly. She immediately implemented reforms: transparent budgeting, competitive bidding for all contracts, and a streamlined process for architectural approvals that respected homeowner rights. The new board also voted to formally recognize that front walkways on private property were not subject to HOA oversight, effectively ending the absurd policy that started this whole mess. Sharon Patterson eventually pleaded guilty to multiple felony charges and was sentenced to 3 years in prison, along with restitution to the HOA. Her husband received probation and was ordered to repay his share of the embezzled funds. As for me, I kept my walkway. Every time I walk on those stone pavers, I think about how a simple dispute over property rights exposed a much larger corruption scheme. I also think about how important it is to stand your ground when you know you are right, even when it feels overwhelming. Marcus Chen and I stayed in touch, and he ended up representing several other homeowners in disputes with overreaching HOAs. He told me that my case became a teaching example in HOA law courses, illustrating the limits of HOA authority and the importance of proper governance. Helen Tanner transformed the HOA into something functional and fair. She focused on actual community improvements, organized neighborhood events, and made sure that homeowners felt respected rather than harassed. Property values in Meadowbrook Estates actually increased under her leadership, proving that an HOA does not need to be tyrannical to be effective. One evening in early spring, about 8 months after the whole ordeal began, I was sitting on my front porch when Helen walked by with her dog. She stopped to chat. "Your walkway looks great, Xavier," she said with a smile. "Thanks. I am pretty attached to it now, I bet. You know, what you did took real courage. A lot of people would have just given in." I was too stubborn to give in, but I am glad it worked out the way it did. Sharon needed to be stopped. She terrorized this neighborhood for years. I am just sorry it took a lawsuit to expose her. Better late than never. Helen's dog pulled on the leash, eager to continue the walk. "By the way," she said, "we are having a community barbecue next month. You should come. Bring friends. I will be there." As she walked away, I looked out at the neighborhood. The sun was setting, casting long shadows across the manicured lawns and cookie-cutter houses. Meadowbrook Estates was not perfect, but it was better now. People were not afraid of their HOA anymore. They felt like they had a voice. I thought about the absurdity of the whole situation. $7,000 for a walkway that did not need repairs, threats of foreclosure over property rights. And underneath it all, a scheme to steal from the very people Sharon Patterson was supposed to serve. It reminded me that systems of power, no matter how small, need accountability. An HOA is just a neighborhood organization, but when the people in charge abuse that power, the consequences can be devastating. It is easy to dismiss HOA disputes as trivial suburban drama, but for the people living through them, it is anything but trivial. It is your home, your investment, your peace of mind. I also learned that standing up for yourself can inspire others. After I filed my lawsuit, 8 other homeowners found the courage to speak up. After Sharon was arrested, dozens more came forward with stories of abuse. One person's refusal to back down created a domino effect that changed an entire community. The legal system, for all its flaws, worked. Marcus Chen navigated the complexities of property law and HOA regulations to build a strong case. The judge took the matter seriously. The county attorney prosecuted the criminal charges. Justice was not instant, but it was real. In the months that followed, I received occasional emails from people in other HOAs facing similar battles. Some asked for advice, others just wanted to share their stories. I always responded with the same message. Document everything, know your rights, and do not be afraid to fight back when you are in the right. One particularly memorable email came from a man in Florida who was being fined for having a vegetable garden in his backyard. The HOA claimed it violated aesthetic standards, even though the garden was not visible from the street. I connected him with Marcus, who agreed to consult on the case. Last I heard, the homeowner won and the HOA was forced to revise its rules. Another woman in Texas reached out after her HOA tried to force her to remove solar panels from her roof. In Texas, there are specific laws protecting the right to install solar energy devices, but her HOA was ignoring those laws. I pointed her to the relevant statutes, and she successfully challenged the HOA's decision. These stories reinforced something I already knew. HOA abuse is not rare. It happens all over the country, in communities large and small. The power dynamic is inherently unbalanced. The HOA is a corporate entity with resources and authority, while the individual homeowner is often isolated and intimidated. But that does not mean homeowners are powerless. Laws exist to protect property rights. Courts exist to resolve disputes. And when people band together, they can challenge even the most entrenched systems. My walkway became a symbol of that resistance. It was a small thing, just a path made of stone, but it represented something larger. The right to control your own property, to make decisions about your own home, to live without arbitrary interference. Sharon Patterson thought she could bully me into submission. She thought that threats of liens and foreclosure would scare me into compliance. She underestimated my stubbornness and my willingness to fight. More importantly, she underestimated the power of the truth. When Marcus subpoenaed those financial records, when the auditor uncovered the embezzlement, when the prosecutor filed charges, the truth came out. Sharon's authority was not legitimate. It was built on fear, manipulation, and corruption. And when that foundation crumbled, so did her power. I sometimes wonder what would have happened if I had just paid the $7,000, if I had let them rip out my walkway and install generic concrete, if I had accepted the injustice and moved on. Sharon would still be in power. The embezzlement would have continued. Other homeowners would still be suffering under her tyranny, but I did not pay. I did not back down. And because of that, a corrupt HOA president went to prison, a neighborhood was liberated, and dozens of homeowners found their voice. The legal battle was stressful. There were moments when I questioned whether it was worth it. The time, the money, the emotional energy, it was a lot. But in the end, it was absolutely worth it. Not just for me, but for everyone in Meadowbrook Estates who had been wronged by Sharon Patterson. Marcus told me that the case also had broader implications. It set a precedent in Arizona about the limits of HOA authority over private property. Other lawyers were citing it in their own cases. Judges were referring to it when making rulings. My stubborn refusal to let an HOA bulldoze my walkway had ripple effects far beyond my neighborhood. As spring turned to summer, life in Meadowbrook Estates settled into a comfortable rhythm. Helen Tanner's leadership brought stability and fairness. The new board focused on actual community needs rather than petty enforcement. People started taking pride in their neighborhood again. I made some improvements to my house that year. I added a small fountain to my front yard, installed new lighting along the walkway, and planted some desert-friendly landscaping. I submitted the plans to the Architectural Review Committee, more out of courtesy than legal obligation. They approved everything within a week, with a note thanking me for the thoughtful design. That simple interaction felt like validation. The system could work when the people in charge acted in good faith. Architectural review did not have to be a weapon. It could be a tool for maintaining community standards while still respecting individual property rights. I also stayed involved in the HOA. I attended meetings, volunteered for committees, and made sure that the reforms Helen implemented were sustained. Accountability requires vigilance. Just because Sharon Patterson was gone did not mean the problems could not resurface with someone else. One of the most satisfying moments came during a board meeting in July. A homeowner asked about the policy for front walkways, mentioning that his concrete path was cracking, and he wanted to replace it with pavers. Helen looked directly at me and smiled. Front walkways on private property are not subject to HOA approval, she said. As long as it is safe and well maintained, you can use whatever material you prefer. The homeowner looked relieved, thanked the board, and sat down. After the meeting, he approached me. "I heard about what you went through last year," he said. "Thank you for fighting that battle. It makes a difference for the rest of us." "Just standing up for what was right," I replied. "Still, not everyone would have done it." That exchange reminded me why the fight mattered. It was not about me. It was about establishing a principle that would benefit everyone who came after. The criminal trial for Sharon Patterson took place in September. I attended as a witness, though my testimony was not ultimately needed. The financial evidence was overwhelming. Sharon's defense attorney tried to argue that she had made accounting errors, not intentionally stolen money, but the prosecution dismantled that argument with detailed records showing the deliberate nature of the fraud. The judge sentenced Sharon to 3 years in prison, calling her actions a betrayal of trust and a violation of fiduciary duty. He also ordered her to pay full restitution to the HOA, which would likely take years given her financial situation. As I left the courtroom, I felt a sense of closure. Justice had been served. The person who had tried to abuse her power was being held accountable. The system, imperfect as it was, had worked. I ran into Patricia from the management company in the hallway. She approached me cautiously. "Mr. Brooks, I want to apologize again for how this was handled. We should have caught the financial issues much sooner." "You should have," I agreed, "but at least you took action when it came to light. We have implemented new oversight procedures for all the communities we manage. This should never happen again." "I hope not." She hesitated, then added, "For what it is worth, I think you did the right thing. It took courage. It took stubbornness," I corrected. "But thank you." Life moved on. The seasons changed. My walkway endured, looking as good as the day I installed it. Every time someone complimented it, I felt a small sense of pride, not just in the craftsmanship, but in what it represented. That stone path was more than a walkway. It was a testament to the importance of standing your ground. It was a reminder that individuals can challenge institutions and win. It was proof that corruption, even in something as mundane as a homeowners association, could be exposed and punished. I kept in touch with several of the homeowners who had come forward during the investigation. We formed an informal support network, sharing information about HOA laws and offering advice to people facing similar situations. Helen Tanner joked that we were like a neighborhood watch, but for HOA abuse instead of crime. In a way, that was exactly what we were. We were watching, we were vigilant, and we were ready to act if someone tried to abuse their power again. As the 1-year anniversary of the initial invoice approached, I decided to throw a small party. I invited Marcus Chen, Helen Tanner, and the other homeowners who had supported me throughout the ordeal. We gathered in my backyard on a warm August evening, grilling burgers and sharing stories. Marcus raised his beer in a toast to Xavier, who refused to back down when it would have been easier to just pay up and move on. Everyone raised their glasses. "To Xavier, and to all of you," I added. "None of this would have happened without people willing to speak up and share the truth." Helen smiled. "To holding power accountable, no matter how small." We clinked glasses and drank. The conversation flowed easily, touching on everything from neighborhood gossip to political debates to plans for future community improvements. It felt good to be surrounded by people who understood what we had been through and who were committed to making sure it did not happen again. Later that evening, as the party wound down and people started to leave, Helen pulled me aside. "You know, Xavier, you could run for the board." "We have an opening next year," I laughed. I do not know if I am cut out for HOA politics. You fought an HOA and won. I think you are more than cut out for it. Let me think about it. We need people like you, people who care about doing things right. As I cleaned up after the party, I considered her suggestion. Serving on the HOA board would be a commitment, but it would also be a way to ensure that the reforms we fought for were sustained. It would be a way to give back to the community that had supported me. I decided to think about it seriously. Maybe next year I would run. Maybe I would continue the work from the inside, making sure that Meadowbrook Estates remained a place where homeowners were respected and power was exercised responsibly. But for now, I was content. My walkway was intact. Sharon Patterson was in prison. The HOA was functioning properly, and I had learned valuable lessons about courage, persistence, and the importance of fighting for what is right. Standing on my front porch that night, looking at the stone pavers illuminated by the new lighting I had installed, I felt a deep sense of satisfaction. This was my home. This was my property, and no one was going to take that away from me. The battle over a walkway had turned into something much bigger. It exposed corruption, changed a community, and set legal precedents. It connected me with people I would not have otherwise met and taught me lessons I would carry for the rest of my life. Most importantly, it proved that ordinary people, when pushed too far, can stand up to institutions and win. It proved that justice, while sometimes slow, is attainable. It proved that doing the right thing, even when it is hard, is always worth it. My walkway stands as a monument to that truth. Every stone, every carefully placed paver, represents a choice to fight rather than surrender. It represents a refusal to be bullied. It represents the belief that your home is your castle, and no HOA has the right to invade it without just cause. As I walked inside and locked the door behind me, I smiled. Tomorrow would bring new challenges, new projects, new opportunities. But tonight, I could rest easy knowing that I had fought the good fight and won. The stone walkway leading to my front door would remain exactly as I built it, a symbol of resistance and a reminder that even the smallest battles can have the biggest consequences. And whenever someone asked about it, I would tell them the story not to brag, but to inspire. Because if I could stand up to an abusive HOA and win, anyone could. That is the legacy of my walkway. Not just stone and mortar, but principle and courage. And that is something worth far more than $7,000.